Well, it is actually a great pleasure to be here. It's always lovely to be back in Cambridge. And of course, I was asked to do this by Lord Woolf, and Lord Woolf is not a man you say no to. Now, he asked me to give this lecture some time ago, knowing that I had given it previously in Oxford. So sorry, Cambridge, you are the second venue for the delivery of this lecture, but I have tried to update and adapt it a little bit. I've been interested in the subject of religious dress since the 1990s, when I was in the family division of the High Court, trying a child care case in which the local authority alleged that a young baby's serious head injuries had been caused non-accidentally by one or both parents. The father was a doctor from Pakistan, training for membership of the Royal College of Physicians. The mother was an arts graduate from Pakistan, but they had decided that she would go into full purdah when they were here. This meant a long robe, a face veil, a headscarf, and a black gauze shroud covering the whole of her head and upper body. Now, parents are compellable witnesses in care cases, and it was essential that I heard her evidence. But we had an easy solution in the case. Care proceedings are held in private. The judge was a woman, me. Counsel for the local authority was a woman. Counsel for the child's guardian ad litem was a woman. Counsel for the parents was a man. But it was agreed that she should give evidence behind a screen. Thus, the only male who could see her face in court was her husband, and the only counsel who couldn't see her was her own counsel, which was quite a weird experience, as he subsequently explained to me. He's a good friend of mine. But that experience left me in little doubt of the importance of seeing the face of a witness giving evidence. This mother's love for her children was quite apparent. So too was the fact that, from time to time, she was repeating a rehearsed script rather than giving me her true recollection of what had taken place. Well, my dilemma was easily solved, but the dilemma facing His Honour Judge Peter Murphy, who happens to be an exact contemporary of mine reading law in this university, but we hadn't realised it until later. Anyway, in the Crown Court at Blackfriars in September 2013 was not so easily soluble. He was presiding over the trial by jury of a defendant charged with witness intimidation, who appeared in the dock wearing a burqa, a loose black shroud covering the head and body, and a niqab, a black veil covering the whole of her face except for her eyes. He was concerned only about the face covering. Obviously, in such cases, one potential problem is identification, making sure you've got the right defendant. But that was solved by a female police officer who knew the defendant, seeing her in private without her niqab, and giving evidence that she was sure that the person in the dock was the person accused. It would be more difficult, of course, if identification had been an issue. But the more serious problems were whether she should be uncovered while giving evidence, so that the jury would be able to assess her credibility, and generally during the trial, so that the jury would be able to watch her reactions to what was going on when others were giving evidence, or counsel were making their submissions, or the judge was delivering his summing up. After a comprehensive review of the principles and the authorities, Judge Murphy ruled that she was free to wear the niqab during the trial, except while giving evidence. That she might not give evidence wearing the niqab, but she could give evidence behind a screen, shielding her from public view, but not from the view of the judge, jury, and counsel. Or alternatively, she could give evidence by live video link. He also ruled that no drawing, sketch, or other image of any kind, while her face was uncovered, could be made, disseminated, or published outside court. Judge Murphy also expressed the hope that Parliament, or a higher court, would review the question sooner rather than later and provide a definitive statement of the law to trial judges. The then Lord Chief Justice, Lord Thomas, at his press conference soon afterwards, said he hoped to issue guidance in the fairly near future. But this didn't happen, and it hasn't happened since. The problem seems to have receded. But the Equal Treatment Bench Book, issued by the Judicial College, does now contain some passages on wearing the veil in court. By the veil, they mean either or both of the burqa and the niqab. The hijab, or Islamic headscarf, is not a problem. The guidance points out that it is not for the court to seek to resolve doctrinal conflicts about whether wearing the veil is mandatory. But the right to freedom of religion is not absolute. In both criminal and non-criminal cases, the identity of a witness or party can be established in private by a female member of staff. Ideally, the issue should be addressed before the hearing. In non-criminal cases, the judge can ask anyone giving evidence to remove her veil, but only if a fair trial requires it. Arrangements to minimize discomfort or concern, such as screening, limiting the number of observers, and prohibiting visual images being created from her appearance, must be considered. So all of this is completely consistent with Judge Murphy's rulings. Curiously, in relation to non-criminal cases, the guidance points out that, quote, science and a growing understanding indicates the difficulties with and the possible fallibility of evaluation of credibility from appearance and demeanour in the somewhat artificial and stressful circumstances of the courtroom, end quote. While in relation to criminal cases, judges are advised to be, quote, particularly careful to point out that wearing the veil might impair the court's ability to evaluate the reliability and credibility of the wearer's evidence. Jurors might assess what is said in ways that include looking at an individual's face and demeanour, end quote. I have difficulty reconciling those two statements, but there we go. But of course, court proceedings are not the only context in which the question of religious stress arises. It comes up far more frequently in schools and other educational establishments and in the workplace, where there are often rules about what pupils, students, or employees may and may not wear. So what's the law about it? Well, there are two main sources of the relevant law. The first is Non-Discrimination Law, which is now contained in the Equality Act 2010, and the second is Human Rights Law, which is contained in the Human Rights Act 1998. Non-discrimination law is largely derived from European Union law, although there is some what we call gold plating. That means that the UK has gone further to protect the rights than is required by European Union law. It does it quite often. And this applies to the suppliers of employment, accommodation, goods and services, whether in the public or the private sectors. It used only to cover discrimination on grounds of race, although widely defined to include ethnicity and sex. But in a case called Mangler and Dowell Lee in the 1980s, the House of Lords held that Sikhs were an ethnic group for this purpose. And in the case concerning the JFS school in 2009, the Supreme Court confirmed, as had always been assumed, that Jews were also an ethnic group for this purpose. That's not an issue now, as the anti-discrimination laws have been extended to cover discrimination on grounds of religion or belief as well. Discrimination comes in two main forms, direct and indirect. Direct discrimination is where a person is treated less favourably than others because of his or her religion or belief. That is, the religion or belief is the reason for the less favourable treatment. Sikhs, Jews, Muslims or Christians, for example, are singled out for less favourable treatment. That hardly ever happens. Indirect discrimination is where an employer or a service provider applies the same rules or practices to everyone, but those rules put, say, Sikhs, Jews, Muslims or Christians at a particular disadvantage when compared with others who don't share their religious beliefs, and the individual suffers that disadvantage. The distinction between direct and indirect discrimination is important because, as a general proposition to which there are only a few exceptions, direct discrimination cannot be justified or excused. Indirect discrimination, on the other hand, can be justified if the employer or service provider can show that the rule in question is a proportionate means of meeting a legitimate aim. It's the rule that's got to be justified, not the discrimination. In the Sikh case, Mandla and Dowell Lee, for example, the complaint was that a private school had discriminated against a Sikh boy by refusing to admit him unless he removed his turban and cut his hair in accordance with the school rules. The House of Lords held that this was indirect rather than direct discrimination. The rule applied to everyone, whether they were a Sikh or anybody else. But it put the Sikh boy at a disadvantage compared with boys who didn't share his beliefs. They also held that it could not be justified. In that case, because it was the very fact that wearing the turban was a manifestation of his ethnic origins, which was said to justify the rule. But the justification has to be independent of the complainant's ethnic origins. Nowadays, I suspect that the school could have thought of a better justification than that, one that was independent, because I'll come on to some of the justifications that have been considered in later cases, had it wanted to do so. But I also suspect that nowadays the school wouldn't want to impose that rule. There we are. It is quite possible for employers and service providers to have reasons for their rules which are independent of the religion or ethnicity of the complainant and are sufficient to justify them. A very well-known example is the Asmy and Kirklees Metropolitan Borough Council case. The complainant was employed as a bilingual support worker at a school. As a devout Muslim, she was accustomed to wearing a face veil in the presence of adult males. The school refused her request to do so when working with male teachers because obscuring the face and mouth impeded her communication with the pupils. The school had conducted a comparison of her work both with and without the veil. This was indirect rather than direct discrimination because the school would have said exactly the same to anyone else who wanted to cover their face for whatever reason. No, they wouldn't have let a male teacher wear a balaclava helmet, for example. And, however, it was justified. The aim was to improve the educational performance of the pupils, especially those from minority ethnic backgrounds, for most of whom English was a second language. And the means chosen were proportionate because the quality of her communication with the pupils was much better without the veil and could not be achieved by other means. Now that approach is consistent with two Grand Chamber decisions in the Court of Justice of the European Union. That's the Luxembourg Court, both of which were decided in March 2017. In Bugniau and Micropole, the complainant was a design engineer who wore an Islamic headscarf. I don't find it helpful to refer to the hijab as a veil because it's not covering the face and it raises completely different issues. She was sacked after a customer had objected to her wearing it on site. The company argued that taking account of the customer's wishes made it a genuine occupational requirement not to wear the scarf, thus an answer to a claim even of direct discrimination. The court rejected that argument, but it pointed out that it was not clear whether this was a case of direct discrimination, a difference of treatment based directly on her religion or belief, or whether the company had a general rule prohibiting the wearing of any visible sign of political, philosophical, or religious belief. And the court said that the latter might be indirect discrimination, but it could be justified by a legitimate aim, such as a policy of neutrality vis-à-vis the company's customers. The court cross-referred to the case of Akbita and G4S. Now, Ms. Akbita began working for G4S as a receptionist in 2003. In 2006, she told them that she intended to wear an Islamic headscarf in the future. She was told that the wearing of visible political, philosophical, or religious signs was contrary to the company's position of neutrality, and an express rule was shortly afterwards promulgated to that effect. She continued to insist, and she was sacked. The Court of Justice of the European Union confirmed that a prohibition based on such a rule did not constitute direct discrimination, because it could apply to anybody. But it might be indirect discrimination unless it was justified as a proportionate response to a legitimate aim of political, philosophical, and religious neutrality. And this might be the case, provided that the policy was genuinely pursued in a consistent and systematic manner. Justification is a matter for national courts. It's not a matter for the Luxembourg Court. But the national court should consider whether it would have been possible to offer the employee a non-customer facing role. But might there not be a prior question? Adopting the legitimate aim of political, philosophical, and religious neutrality might surely be too easy a way out for employers. It's an easy thing to say, isn't it? Should there not be some consideration of the nature of the employer's business, the identity and expectations of its customers, the nature of the workforce, and the type of work carried out? In short, some evaluation of the impact upon the employer's commercial interests if the right to manifest a religious belief is respected. So those decisions have been quite considerably criticised as not being subtle enough. An example of how a national court might approach such questions, although it arises under the German constitution rather than European Union law, is a 2015 decision of the German Federal Constitutional Court. This considered similar arguments in relation to Muslim teachers in state schools who were asked to remove their headscarves. One was given a formal warning for wearing a beret and a polo neck jumper instead. Now, I have an Orthodox Jewish friend who always wears a very elegant snood, which covers her hair, and it looks very good. But so clearly she was using a beret to the same effect. But she only got a warning. The other was sacked for refusing to remove her headscarf. There was a state law prohibiting teachers from publicly expressing views of a political, religious, ideological, or similar nature, which were likely to endanger or interfere with the neutrality of the state vis-à-vis pupils and parents, or to endanger or disturb the political, religious, or ideological peace at school. Although, extraordinarily, the representation of Christian and Occidental education and cultural values did not amount to an infringement of this law. Now, the court held that the general prohibition on teachers expressing their religious beliefs through their outward appearance violated their freedom to profess their faith under the German Basic Law. The interference was a serious one. The aim of preserving school peace and neutrality was legitimate, but the measure had to respond to a concrete threat to those aims, which had not been demonstrated. Wearing a headscarf does not, by itself, threaten those aims or interfere with the pupil's own freedom of faith, as long as staff did not seek to promote their faith or influence pupils. So a much more nuanced approach to the matter than the Luxembourg Court had shown. And, of course, they held that the exception for Christian and Occidental values was discriminatory and therefore void. So that's general approach under EU equality law. Going on to human rights law, the German court was in fact construing provisions of the German Basic Law, which are very similar to Article 9 of the European Convention on Human Rights. Now, my guess is that everybody in this room can recite Article 9 of the European Convention on Human Rights off by heart. Just in case you can't. Everyone has the right to freedom of thought, conscience, and religion. This right includes freedom to change his religion or belief, and freedom, either alone or in community with others, and in public or private, to manifest his religion or belief in worship, teaching, practice, and observance. But Article 9.2 says, freedom to manifest one's religion or beliefs shall be subject only to such limitations as are prescribed by law and are necessary in a democratic society in the interests of public safety, for the protection of public order, health or morals, or for the protection of the rights and freedoms of others. Now this too has come up in the context of school uniforms and employers' dress codes. I first encountered it in the House of Lords in the case of Shabina Begum, a different Shabina Begum. It's quite a common name, and the governors of the Denby High School. A Muslim schoolgirl had not been allowed to wear a jilbab at school. Now this is not a veil, it's a long black garment which covers the body from the neck down. The school uniform policy permitted the headscarf and the shalwar kameez. It had been carefully worked out in agreement with the local community. The majority of the House of Lords held that this was not even an interference with her right to manifest her religion, as her family had deliberately chosen to send her to that school, and she could have gone to another one where she would have been allowed to wear the jilbab. Lord Nichols and I held that it was an interference. But we all five of us held that it was justified. As I put it, the school was trying to balance the conflicting considerations of respect for diversity and promoting social cohesion and the freedom of others to develop their full potential. Quote, social cohesion is promoted by the uniform elements of shirt, tie and jumper, and the requirement that all outer garments be in the school colour. But cultural and religious diversity is respected by allowing girls to wear either a skirt, trousers, or the shalwar kameez, and by allowing those who wish to do so to wear the hijab. This is indeed a thoughtful and proportionate response to reconciling the complexities of the situation. And this is demonstrated by the fact that girls have subsequently expressed their concern that if the jilbab were to be allowed, they would face pressure to adopt it, even though they did not wish to do so. Now, later case law in the European Court of Human Rights, the Strasbourg Court, endorses the minority view of Lord Nichols and myself that the school uniform policy was an interference with Shabina's right to manifest her religion. But I suspect, as you will see from cases I'm going to talk about, that they would also say that the interference was justified. They had a series of admissibility cases against France, complaining about the exclusion of pupils from school for refusing to remove either Islamic headscarves or Sikh keskis, under turbans. A French law of 2004 prohibited the wearing of all conspicuous signs of religious faith during lessons. The Strasbourg Court held that this was a restriction on the pupils' freedom to manifest their religion. However, it was in accordance with the law, and it pursued the legitimate aims of protecting the rights and freedoms of others and public order. It was also meant to protect the constitutional principle of secularity, laïcité, which is a fundamental principle of the French Constitution, an aim which was in keeping with the values underlying the Convention and the Court's case law. So they held the complaints inadmissible. The same arguments were deployed before the United Nations Human Rights Committee in another Sikh case from France. A young Sikh complained that being expelled from school for refusing to remove his keski was a breach of Article 18 of the International Covenant on Civil and Political Rights of 1966, which for this purpose is virtually identical to Article 9 of the European Convention. The committee recognised that the principle of secularism, laïcité, was in itself a means of protecting the religious freedom of all the population, and also that the 2004 law had responded to some real incidents of interference with the religious freedom of pupils, and sometimes even threats to their physical safety. So it served the purpose of protecting the rights and freedoms of others, public order and safety. However, France had not furnished compelling evidence that by wearing his keski, the complainant would have posed a threat to the rights and freedoms of other pupils, or to good order in the school. Furthermore, his permanent exclusion from school was disproportionate and had led to serious effects upon the education he was entitled to receive. There was a similar disparity of views between the Strasbourg Court and the UN Human Rights Committee in another Sikh case from France. French law required people to appear bareheaded on their passport and other identity photographs. The Strasbourg Court held that it didn't amount to an interference with the freedom. It did amount to an interference with the freedom to manifest the Sikh religion by wearing a turban at all times, but it was prescribed by law and pursued the legitimate aim of ensuring public safety by enabling drivers to be identified with the maximum degree of certainty and verifying that they were authorised to drive the vehicle concerned. And the requirement was only a sporadic one. Now, the Human Rights Committee agreed that the requirement pursued a legitimate aim. However, France had not explained why wearing a turban covering the top of the head and part of the forehead, but leaving the rest of the face clearly visible, would make it more difficult to identify a person who wore the turban at all other times than if he were to appear bareheaded. And although it was a one-off requirement, it interfered with his freedom on a continuing basis, because he could be compelled to remove his turban during identity checks. So there are two examples of the UN Committee taking a more nuanced approach than the Strasbourg Court. Since then, Strasbourg has decided at least two important cases about the wearing of religious dress or symbols. Ouida and the United Kingdom concerned a woman working for British Airways and a National Health Service theatre nurse, who were both prohibited from wearing a discreet cross at work. They'd both complained of discrimination to an employment tribunal, and they'd lost, on the grounds that this wasn't indirect discrimination, because the rules didn't put Christians generally at a disadvantage, because wearing a cross is a matter of personal choice and not a religious requirement. As an aside, it's just this approach which makes Christians feel that they are being discriminated against, because there is not much that they're actually required to do. Christianity is a very lax religion in many, many respects. Of course, it means a lot to those who choose to manifest their faith in this way. Now, the Strasbourg Court held that this was indeed an interference with their right to manifest their religion. The fact that they could go and get another job didn't stop its being an interference. In the British Airways case, they also held that it wasn't justified. They accorded much more weight to the fundamental right of the individual than the Court of Justice of the European Union had done in the two cases I mentioned. They said, this is a fundamental right because a healthy democracy needs to tolerate and sustain pluralism and diversity, but also because of the value to an individual who has made religion a central tenet of his or her life to be able to communicate that belief to others. Against that was the employer's wish to project a certain corporate image. While the aim was legitimate, the English courts had accorded it too much weight. It was a discreet cross, which couldn't have detracted from her professional appearance. The wearing of other previously authorised items of religious clothing, such as turbans and hijabs, had not had a negative effect on British Airways' brand or image. And the rules had been changed soon afterwards anyway. The nurse, on the other hand, was different. The rule against wearing any form of jewellery was for health and safety reasons, which had greater weight, and the local courts were better able to judge whether it was justified. That decision has had a very beneficial effect in discrimination cases, because in deciding discrimination cases, the employment tribunals now know that they have to consider whether, if they decided them against the Ouidas of this world, they would be interfering with their right to manifest their religion. So it's had a very good effect. Against this might be put the Grand Chamber case of SAS and France. This upheld a 2010 French law banning the wearing of face coverings in all public places unless authorised by law or justified for health or professional reasons, sports practices, festivities, or artistic or traditional manifestations. Banning the face veil sought to guarantee the conditions of living together, to protect the principle of interaction between individuals, essential for the expression of pluralism, tolerance, and broad-mindedness. Basically the same laïcité justification as in the French Sikh cases. This too has not found favour with the United Nations Human Rights Committee. In October 2018, the committee issued 2 decisions finding that France had violated the human rights of 2 women by fining them for wearing the niqab in public. Although the law did not explicitly target Muslim women, the vast majority of people convicted under it were Muslim women. It might be necessary to see a person's face in certain circumstances, for identification or security reasons, but the blanket ban was disproportionate. The concept of living together, relied on by France, was not a fundamental right. France had not established a connection between any fundamental rights of others and the ability to see a veiled woman's face in public. The ban was also discriminatory, distinguishing between Muslim women and others who are allowed to cover their faces under the 2010 law. So traditional manifestations, whatever they might be, but I expect there were masks at processions and things like that. That was okay, but face veils were not. There were 2 dissenters. They accepted that the ban was necessary for security reasons, including the identification of perpetrators after terrorist attacks. One had also contended that the practice of wearing a niqab was a symbol of stigmatizing and degrading women. There were 2 concurring opinions which acknowledged the concern that full face veils might perpetuate gender inequality. But they pointed out that imposing criminal sanctions upon the wearers was not the appropriate way to address this, as opposed to education and awareness raising. When you think about it, it's a classic case of blaming the victims, if indeed they are victims of gender inequality or particular stereotypical views of the role of women. But they were the ones being prosecuted and punished for being the victim of that. Classic, really, isn't it? Why was the UN committee prepared to subject the justifications offered by France to much closer scrutiny than was the Strasbourg Court? Stephanie Berry, in an article in Legal Studies in 2017, suggests that the Strasbourg Court has a longer history of considering such cases, many of them from Turkey, whereas the UN committee was considering these issues afresh. And that could be a good thing. That the 47 member states of the Council of Europe have a predominantly Christian or secular tradition, whereas the UN committee is dealing with a wider diversity of states. That the decisions of the Strasbourg Court are legally binding on the member states, whereas those of the UN committee are only advisory opinions. And also that the Strasbourg Court recognises a margin of appreciation within which views may legitimately differ between member states, whereas the UN committee does not. So, drawing the threads together. First, none of these cases, and nothing in this lecture, has sought to examine the theological basis for the religious views held by the various complainants. One member of the House of Lords in the Shabina Begum case, who happens to have 2 children of the Muslim faith, did express the view that, quote, the notion that the shalwar kameez, school uniform, would not accord with the essential requirements of Islamic modesty for teenage girls seems to me an astonishing one, he said. My attention has also been drawn to 2 sources which state that it is not contrary to Sharia law for a woman to uncover her face when she is giving testimony in court, or for a male magistrate or judge to look at her in order to identify who she is, to make assessments as to her credibility, where this is an issue, and to protect the rights of all concerned. One of those sources is the Australian National Imams Council's explanatory note on the judicial process and the participation of Muslims, which cites several texts in support of those propositions. The other is the well-known compilation by Al-Masri, the reliance of the traveller, which is to the same effect. And when I mentioned this in Oxford last year, the Imam and the Islamic scholars to whom I delivered the lecture at the Oxford Centre of Islamic Studies agreed that all of that was correct. In SAS in France, the court held, repeating the view expressed in Ouida, that provided a complainant's views attain a certain level of cogency, seriousness, cohesion, and importance, quote, the state's duty of neutrality and impartiality is incompatible with any power on the state's part to assess the legitimacy of religious beliefs or the ways in which those beliefs are expressed, end of quote. The Equal Treatment Bench Book is right to say that it is not for us to question the validity of a person's beliefs, provided they are sincerely held. Second, it's unlikely that a ban on all or any items of religious dress or symbols will be considered direct discrimination on religious grounds for the purpose of the Equality Act 2010, provided that the rule is not aimed at a particular religion as opposed to a particular type of dress or symbol. On the other hand, such a ban could be indirect discrimination for the purpose of the 2010 Act because it places adherents of a particular faith at a disadvantage when compared with people who don't share that faith. Since Ouida, this should include Christians, even though they are mostly not obliged to manifest their religion by wearing a religious symbol or dress, as much as it should include Jewish or Muslim women who feel obliged to cover their hair or, in some cases, their face. The focus would then turn to whether the ban was a proportionate means of achieving a legitimate aim. Third, the Equality Act only applies to certain kinds of acts by employers and service providers, such as sacking an employee or excluding a pupil from school. It doesn't apply to every act which might be seen as discriminatory, but it does apply to private as well as public employers and service providers. The Human Rights Act, on the other hand, applies only where the acts of public authorities are incompatible with the Convention rights. This includes the acts of courts and tribunals, which is why it might otherwise be thought that acts of private bodies, such as British Airways, wouldn't be caught. Fourth, school uniforms, employers' dress codes, and requirements for photo identification may all amount to interferences with the right to manifest one's religion under Article 9. The fact that you may go to another school or another employer doesn't mean that there's no interference, although it may make the interference that there is easier to justify. Once again, therefore, we're back to justification. Is the interference or limitation a proportionate means of achieving a legitimate aim? Fifth, the cases have discussed a variety of possible legitimate aims, ranging from protecting a corporate image, through preserving other schoolgirls' right to choose, health and safety considerations, public safety, interaction and communication between individuals, preserving neutrality as between different political, religious, and philosophical views, to securing the basic principles of a fair trial. The right to a fair trial being another of the fundamental rights guaranteed by the European Convention. But having a legitimate aim is not enough. The interference with the particular person's rights has to be a proportionate means of achieving that aim. So back to where I started, with what one does in court. It's not for me to give guidance to the courts of England and Wales as to the approach that they should adopt. I can only decide the cases which come before me in the Supreme Court. I agree with Judge Murphy, however, that it is a question of law, not simply judgecraft. But the question of law depends upon balancing, as I've explained, the freedom to manifest one's religion against the justifications for interfering with that freedom. And judgecraft, in the sense of trying to plan things in advance and trying to find sensible accommodations for the different considerations, can do a good deal to anticipate the problems and secure a reasonable accommodation. I also agree with him that in this particular context, it's face coverings and not other items of dress which present the dilemma. We do take it for granted in this country that observing a person's facial expressions, body language, and general demeanour are an important part of assessing their credibility, and the Quranic sources mentioned earlier seem to share that view. Our adversarial trial system depends crucially on testing a witness's evidence through cross-examination. Now, I suspect that most advocates would find it difficult to imagine how one would cross-examine a witness whose face one couldn't see. I've tried to examine it myself, to imagine it myself, and it's really difficult to think how you would go about the intense interaction which cross-examination is. Others, of course, including the bench book in its two contradictory remarks, have questioned whether that is in fact so, particularly as demeanour is so culturally determined. What seems shifty to some of us may in fact be a mark of respect in the witness. But the same expectation should apply to all witnesses. The ingredients of a fair trial should be the same for all, regardless of their religious or other beliefs. And we wouldn't let people cover their faces in court if they didn't have a religious reason for doing so. So if one's trying to treat everybody equally, one should treat them all the same, or let everybody be bailed in court. Now, difficult to imagine. A rather more difficult question is whether the magistrates, judge or jury should be able to observe a defendant's demeanour throughout the trial. I would much have preferred to be able to watch the doctor's wife's reactions to what was being said throughout the proceedings. When her husband was giving evidence, for example, I'd have liked to look across at her and see what she was thinking of his evidence. When the doctors were giving evidence as to the injuries to her baby, I'd have liked to look at her and see what her reaction was to that, etc., etc. But I think I could weigh up the evidence without doing that. But another question is how far the same should apply to the other actors in the trial process, the magistrates, judge, jurors, and court officials. Fortunately, how to balance these considerations is a matter for the trial judge and not for me. But when I sit in court number 1 at the Supreme Court, I'm very conscious of one of the portraits hanging there. It's a portrait of Sir John Fielding, who succeeded his half-brother, Henry Fielding, the novelist, author of Tom Jones, as chairman of the Middlesex Magistrates in 1754. Sir John was blind. He was known as the Blind Beak of Bow Street. He was said to be able to recognise 3,000 criminals by the sound of their voices. But he was also a notable social and penal reformer. So a little bit of me is wondering, if he could do it, why couldn't we all? But another bit of me is persuaded of the value of the face-to-face interaction which I experienced so vividly all those years ago. Thank you.